is the possibly most interesting session of the day. And who misses this obviously misses the crux of the conference. So idea of having a debate, right? Obviously, this is a debate created to bring thoughts on both the sides, and therefore this is not in a way personal views of any of the speakers sitting here, because we have thrust upon them the topic and which side they will take for the topic. But idea is obviously to evoke some discussions around important topics, which sometimes during the panel discussions does not come out in the way and the manner in which the discussions and the thought process should evolve. And also this becomes base for something for the future for people to deliberate upon and bring about some change. And we were not sure when the topic was discussed and finalized, as Nitin and Vishrov was talking in the opening section. I think everyone is talking about where things are going wrong. I think Tushar also talked about it. Some of the other speakers in the plenary section as well spoke about it. It also came about in the issues related to appointment of arbitrators, ethical issues, integrity, and so on and so forth. But nobody calls it what it leads to. And I think Tushar also said that putting it as mildly as I can, but as clearer as I can be, that government is not at a level playing field, and everybody knows what does that mean. So I think this topic obviously was one of the connecting points or pointers or thread between many sections today. But I think we don't have to look at this topic as in a unidimensional way, right? When we say institutional arbitration can effectively curb corruption in dispute resolution, immediately when you say corruption, one would visualize somebody coming with a bag of cash and exchanging the bag with the arbitrator or the counsel or the parties. That's not real focus in that sense. I think corruption has a much wider sense. Corruption is not limited to cash or money or quid pro quo or things like that, but it is a much larger topic, particularly in a setting where you are trying to do justice or you are trying to resolve disputes in a private fashion, right? Because here there is a lot of autonomy, there is a lot of autonomy given to the parties, or there is a lot of discretion. Evidence Act doesn't apply, no procedural laws apply. Technically, one can go beyond the usual legal principles in that sense, while broadly everything applies in an arbitration scenario. But ultimately, people look at it as to how you can resolve this dispute rather than look at the technicalities. So, all of that put together, there is a lot of chance that there can be biases, there can be corruption in many different ways. While one aspect was raised today that why government is going away from arbitration is government doesn't have a legal playing field. But I think from private parties' perspective, when retired judges or senior advocates are appointed on the arbitral panels, private parties may feel that government will have the upper hand because they can obviously offer things very different, and they may have other aspirations or other issues as part of the topic. Plus, there can be inherent biases, there can be corruption in many different ways. So, I think the whole idea of today's topic is obviously to discuss this topic head on, and therefore we have two sides. One is for the motion, as we have already introduced the speakers, Chung and Mehta, and against the motion, Rebecca, James, and Vishrov, Mukerjee. So idea is to get thoughts on both the sides, and then we have sitting like this for many times in last 20 years, but this is the first time I'm sitting with him after he took the judgeship. So, welcome, Justice Karia, and we are very delighted to have you in this avatar. I hope to have more and more sessions like this. So, idea is we will straight away get into this topic. What we will do is we have a judge and we will have a jury. Jury is all of you sitting on the other side, and therefore your participation would be extremely important. And we have tried to keep some time after both the sides speak, so it doesn't become that we are on the dais and you are just the listeners. I think this topic requires more interaction than just two sides speaking on the topic. So please feel free to give your thoughts, comments, questions. Obviously keep it brief after both the sides speak. But please make your thoughts and make sure you get those opportunities to talk. So before the first speaker for the motion comes, the idea is each side will have one speaker from for the motion and then against the motion, and then we go back to second speaker, the third speaker, and the fourth speaker, and then there will be a very short rejoinder on both the sides. And we'll give them 8 minutes each. So we'll try and wrap it up within 40-45 minutes. So we have good 15 minutes for interaction with the audience. With that, maybe we can start with the votes straight away from the jury at the start. An idea is after the session on both the sides whether there is a change in the mind of the jury, because that would give clear idea as to what jury thinks and what the judge thinks. Maybe they think two different things, but can we have raise of hands vote? The motion is institutional arbitration can effectively curb corruption in dispute resolution. People who agree. Okay, and people who say no. Okay. There are lesser people, let me put it this way, but there are still people who feel that institutional arbitration also cannot possibly curb corruption because motion presupposes the other proposition. So with that, between Katie and Nitin, I don't know who is going first, but your time starts now. You have 8 minutes.
I think I stand up and say, because this topic really requires standing up for everything. So, in a world where justice is blind, corruption ensures that it never sees the day of light. Ladies and gentlemen, esteemed judges and fellow legal minds, we gather here to discuss the pressing issue that undermines the very foundation of our legal system, corruption in dispute resolution. This jury believes that institutional arbitration can effectively curb corruption in dispute resolution, and rightly so. Because in a system where the disease is systematic, the remedy must be structural. Let us be blunt. India ranked 96th out of 180 countries on the Corruption Perception Index by Transparency International, with a score of only 38 out of 100. This emphasizes the perception of corruption. Isn't it startling? Therefore, justice must not only be done, but it must be seen to be done. The motion rightly presupposes corruption exists. After today's morning, when every speaker, though wrapped in terms like integrity and credibility, was unanimous in acknowledging the elephant in the room, that is the corruption. Let us first define our villain. The simplest definition is Oxford, where it says that dishonest or fraudulent conduct by those in power is corruption. In the present context, most apt is how Supreme Court in Vasudev Rao 2004 9 SCC 319 has defined corruption as allowing decisions and actions of a person to be influenced not by right or wrong of a cause, but by prospects of monetary and other selfish considerations. In arbitration, corruption is like a tailored suit which bids only one party and goes out fairness, neutrality and transparency of the process. So, what does transparent corruption look like? Let me paint a picture. Bribery and kickbacks. Nominee arbitrators who are considered as representative and friendly arbitrators. Presiding arbitrators cartel where only a few within themselves appoint the presiding one. Counsel and arbitration nexus where the counsel keeps on appearing before one arbitrator and appoints him. Conflict of interest goes for a toss. Undue influence, fraudulent evidence, enforced documents and testimony being produced, procedural manipulation, and most recent, ghostwriting of awards by copy paste or you know the best. Now, what Indian law has to say on it? Section 12, read with Schedule 5 and 7 of the Arbitration Act, post 2015 and 19 amendments, introduced mandatory disclosure requirements for arbitrators of past and present relationships and specified relationships that raised red flags and mandate disqualification. Section 32 permits setting aside an award if it is in conflict with the public policy, including cases where it was induced or affected by fraud or corruption. Karia, Supreme Court, has said that the corruption goes to the root of the public policy. But let's talk about the elephant in the courtroom, standard of proof. Indian courts have consistently applied a high threshold of clear, cognate and convincing evidence to prove corruption. Courts in venture capital global has clearly held that mere allegation is not sufficient. Now, tell me how a party will get access to direct evidence for a collusion happening in a closed room. How an ad hoc arbitration can figure this particular aspect out. This brings to the root problem. Ad hoc arbitration is structurally incapable of preventing and curbing arbitration. Appointments happen in the drawing rooms, no vetting of arbitrators, no check of conflicts of interest, no scrutiny of repeated appointments, no oversight over procedures, no administrative checks, no red flag system, no standard rules, no recourse if the process goes sideways, no award scrutiny, no threat of blackmailing. So you remember Rajkumar's famous dialogue, जिनके घर शीशे के होते हैं वो दूसरों पे पत्थर नहीं फेंकते. Exactly that's what happening in ad hoc arbitration. Recently the government has capped the amount of the disputes less than 10 crores only to be taken to arbitration. Tushar Bhai in the morning has made this critical point that government being the largest litigant is often denied a level playing field. Now contrast this with the institutional arbitration. Neutral appointment procedures, multiple layers of screening and randomization and selection by a large committee. MCIA itself has 20 plus members, council will select the arbitrator. Mandatory conflict check by a verified neutral wage team. Expert pool of arbitrators, removing the bias, standard rules and procedures, time-bound resolution with penalties for delay. Audit trail, minutes, decision, logs, every move leaves a footprint. Red flag systems, both general and specific. Award scrutiny to flag inconsistency. Justice Karia aptly described in the morning, institutional arbitration as both a gatekeeper and the governance center, a safety net that ensures that arbitrator acts in a fair and free manner. He emphasized institutions can break this vicious cycle with blacklisting policies, anti-corruption rules, and culture of zero tolerance towards corruption. Let's face it, ad hoc arbitration may look cheaper, but it can cost you the integrity. An institution isn't just a building, it's the firewall. My co-speaker, Katie, will delve more deeper into it in international framework. But here in India, over 90% of arbitration in India are still ad hoc. If we are serious about fighting corruption and restore confidence in arbitration, especially for foreign investors and cross-border disputes, we must move the needle towards the institutional forum. So, I leave you with this. You wouldn't trust a hospital with no admission procedure, no surgical protocol, or a doctor being handpicked by a patient, would you? Then why trust ad hoc dispute resolution, something that decides rights, money, and future, with a process so fragile and opaque? Institutional arbitrations does not replace human discretion, but it regulates it, supervises it, and when needed, course corrects it. What we heard today morning, my friends, was not just the diagnosis, but the prescription. An affirmation that if we are to restore public faith in arbitration, institutional arbitration is not an option, but an imperative. And that, my friends, is why this House must and has voted for the motion, because institutional arbitration isn't just an option, it's an antidote to corruption in dispute resolution. I did not intend to speak so much because the House has already voted, but this is only for those who are fence sitting to immediately come this side, because if the future in arbitration has any scope, it is institutional arbitration. Thank you, gentlemen. Thank you, friends.
One thing I can definitely say that institutional arbitration is timely, which will be exactly 8 months. So, please.
Good afternoon, all. And I'd like to start by thanking the MCIA for the kind invitation to speak, followed immediately by an apology for everything that I'm about to say. As it turns out, I also need to apologise to the vast majority of you, but I sincerely hope that by the end of this debate, we will at least explore the ideas enough that we're in with a fighting chance of persuading you. Let's set the scene. What we are looking at here is whether institutional arbitration can effectively curb corruption in dispute resolution. So what are we talking about? Corruption in or of the dispute resolution process itself. Just for clarity, what we are not looking at is underlying corruption in the dispute arising between the parties sometime beforehand. Corruption, as Vyapak has rightly touched on, it's a large, it's a wide concept, and it's inherently difficult to define and identify. But for present purposes, it is very clear that we can be looking at conduct involving tribunal members, the parties, or other relevant stakeholders, witnesses, lawyers, all stakeholders that will be present in both institutional and ad hoc arbitrations. Examples can range from obvious ones such as arbitrators being bribed or improperly influenced to favour a party, other unethical behaviour or conflicts of interest which are not disclosed, fraudulent and improper manipulation of the arbitration process by parties in which the arbitrator is not complicit, for example, tampering with witnesses or other relevant third parties, or the fabrication or tampering with documents that can have a very material outcome and bearing on the outcome. Now, so what are we not here to debate today? We are not here to debate whether corruption can arise in arbitration. That is common ground. We are not here to debate whether it is a problem in ad hoc arbitration. And in fact, and I do think this is important, we are not even necessarily here to talk about whether institutional arbitration is marginally or somewhat better than ad hoc arbitration. The motion that we are discussing is whether institutional arbitration, viewed in and of itself, can effectively curb corruption. And it is on this point that we say that the motion resoundingly fails. And before coming on to why, taking a look at this concept of institutional arbitration. Institutional arbitration is fantastic, and I'll come back to some of the reasons why, in terms of what it can do to improve arbitration processes. And most of my experience has actually been in working on institutional arbitrations rather than ad hoc arbitrations. However, what institutional arbitrations do not do is provide any guarantee whatsoever that it will stamp out fraud, corruption, or the sorts of improper conduct that we've just been discussing just because they have the oversight of the institution to some extent. Now, we have spent some time hearing from my friend about some of the excellent scrutiny, supervision and initiatives that are undertaken by the MCIA and other institutions. And there's common ground that these rules exist. But are these institutional efforts truly capable of curbing corruption? This is where we part ways. We think the answer is clearly no. And it is no because it is unrealistic to expect that arbitration as a process, whether ad hoc or institutional, and institutions with the important role that they play in that process, can be capable of achieving this and stamping it out. Institutions cannot ultimately control the conduct of arbitrators or parties. The root causes or sources of any corrupt or other improper conduct in most contexts under discussion. And this is true no matter what the rules and guidelines say. Even in an ad hoc arbitration context, there are baseline standards provided in national law and the rules that are signed up to, providing for impartiality and fairness. If these are going to be ignored, they're going to be ignored anyway, even if the parties have signed up to a new, slightly more nuanced version of obligation. So with that context laid, it would be good to break it down and look at a few of the key issues, just really so you can see the substance of what I'm saying. The first is, let's look at arbitration as a process. Arbitration is confidential under many sets of institutional rules as well. And so while we've discussed the benefit of sunlight, the benefit of transparency, which is of course in many ways the flip side of confidentiality, you're not in a materially better position in institutional arbitration if in fact what you are looking for is transparency. That is just a trade-off that comes hand in hand. Now, another point is procedural flexibility and the way that the process will unfold. Arbitrators, and I say this without any criticism, I think it is entirely appropriate, are often heavily reliant on parties' own factual and expert evidence. There is a lower threshold for document production than in court proceedings in many countries, at least common law countries. And tribunals can make document production orders a required disclosure, but frankly, failure to comply is unlikely to result in anything other than worst case scenario adverse inferences. What this does not do is flush out or test corruption or fraud in any meaningful way. And it can be very difficult, if not impossible, for arbitrators, even extremely diligent, well-motivated and experienced arbitrators, to spot evidence tampering and other corrupt acts of parties in this context. And in spite of the best efforts of institutions, this is true in institutional arbitration as well. It's just not reasonable to expect the institution to have that degree of oversight of the entire process. Now, arbitrators derive their authority from party consent, what the parties agree, and also just do not have the same robust powers that national courts or regulatory bodies have to actually dig into allegations of corruption or improper conduct on the part of relevant stakeholders in the arbitration process, nor to impose sanctions effectively. So those are the inherent limitations in the process that we're still discussing. Let's turn secondly to the role of institutions. Institutions play a very important role in setting rules that are detailed, provide great clarity, can ensure that arbitrations proceed smoothly and expeditiously, that there's a knowledgeable case registrar team who can ensure that the arbitrations proceed well. And depending on the institution, add a degree of quality assurance to the final award. But what it is not the job of the institution to do is to conduct the procedure that remains with the arbitrators, to supervise every aspect of the arbitration, even if they're in copy, or in fact actually to warrant the quality of the decision on the substance that the arbitrators produce. And just to give one quick example, not directly on the point of fraud, but just on the point of supervision or oversight that's mentioned, I think many in the room will be familiar with the copy-paste judgment which referred to an arbitration case where significant portions of the award were found to be directly copied from earlier rulings. Now, with apologies to my friends at the ICC who are here, that was an institutional ICC arbitration. And everyone familiar with the ICC rules will know this is an institution which does have a quality assurance mechanism. So let's just, at least among this group, be honest and pragmatic about what oversight can reasonably entail. The reality is the procedure tends to move forward primarily with the parties in tribunal with a very valuable but nonetheless somewhat limited degree of visibility from the institutions. Institutions administer... Okay, I'm sorry, I will cut to the chase very quickly. The third area is on appointment of arbitrators. Arbitrators are subject to a duty to act fairly and impartially under many national legal systems in any event. But to the point of nominations, it's important to bear in mind that the majority of nominations in institutional arbitrations are still made by the parties. If you look at any of the relevant case statistics from the ICC, SIAC, the LCIA in recent years, it is clear that the majority is still put forward by parties, and it is extremely rare that those nominations are not endorsed unquestioningly by the institution. And the point about closeness and friendliness that has been raised is a problem. It's a problem for diversity, it's a problem for our community, but it is a problem that exists in any event. We're drawing from the same pool. And this is a point that Vishrov will come back to. Now, mindful of time, I will close there and save any further remarks for us. Thank you.
So, thank you everyone for being here today, and it's great that it's a full house discussing about institutional arbitration and how institutional arbitration can effectively curb corruption in arbitration. I am thankful to the MCIA for the invitation, and of course I support institutional arbitration such as that run by the MCIA in curbing corruption in arbitration. So, my friend says that ad hoc arbitration and institutional arbitration are similar. Ad hoc arbitration provides for independence and impartiality and will also encourage just outcomes in international arbitration. Now, this is where the similarities end between institutional and ad hoc arbitration, because without the institutional oversight that is required in international arbitration, ad hoc arbitration can run astray in respect of the corruption that we're talking about here, which has things to do with conflicts of interest, bias that can be employed in terms of anchor bias or confirmation bias, or even bias that is resulting from frequent appointments of arbitrators. Now let me go into this in a bit of detail. First, the section 12 and 13 of the International Arbitration Conciliation Act, which everyone here will be very familiar with, provides for mandatory disclosure requirements and subsequently allows the parties to challenge the arbitrators under section 13 of the IEC. Now, once the challenge is completed, if the tribunal says that this is unsuccessful, the party seeking to challenge the arbitrator is convinced the challenge is correct, will have to wait for an award to be issued in order to set aside the award under section 34. Now, institutional arbitration is different because it allows the arbitration institution to look at the challenge itself. So, for example, the MCIA has the counsel of the MCIA to look at the challenge, and if the challenge is found to be accepted, the arbitrator is removed and a new arbitrator is appointed, so that the parties don't have to see through the case with the party, with the particular arbitrator that you're saying is, biased or has some apparent bias in the arbitration. And the same goes for the ICC. You have a court of arbitration looking at a challenge. The challenge is decided by the court. If it's accepted, the arbitration is removed at the point in time in the middle of the case. And the same goes for the SIC rules, where the court of arbitration will look at any challenge. And so in this case, institutional arbitration is better than ad hoc arbitration in dealing with challenges to impartiality or independence, and saves the parties costs, in dealing with the case where the arbitration that's being challenged is still in its midst. The second point is that where you have an institutional arbitration over ad hoc arbitration, I call it you take the money out of the equation, because you don't involve the arbitrator in discussions of money. And obviously, in ad hoc arbitrations, there's evidence of frequent appointments by certain arbitrators, in many cases, for particular parties, many times over. And that kind of frequency can lead to bias. For example, in the UK Supreme Court decision on the apparent bias of an arbitrator in Linklaters and Chung, Lord Hodge says that an arbitrator is nominated by one or both parties, right, to act. And the arbitrator is remunerated by the parties to the arbitration in accordance with the terms set out in the reference, and often is ultimately funded by the losing party. He or she is appointed only for the particular reference, and if arbitral work is a significant part of the arbitrator's professional practice, he or she has a financial interest in obtaining further appointments as arbitrator. And nomination as an arbitrator gives the arbitrator a financial benefit. There are many practitioners whose livelihood depends to a significant degree on acting as arbitrators. This may give an arbitrator an interest in avoiding action which will alienate the parties to an arbitration, for example, by assertive case management against the wishes of the legal teams representing the client's cases. It may also give those legal teams an incentive to be more assertive of their side's interests in the conduct of the case than might be the case in a commercial court. And this quote is so relevant in today's international arbitration scene, as well as in India's ad hoc arbitration scene, where oftentimes arbitrators are acting, and that mainly is their job. It follows that they depend on arbitral appointments for their livelihood, and if they need frequent appointments from a particular party, then it's as Shakespeare points out in Merry Wives of Windsor, if money goes before, all ways do lie open. It results in lesser independence and impartiality in the arbitration process, and you get a situation where the arbitrator is in a way beholden to a party for future appointments. By contrast, looking at the institutional appointments, that payment of arbitrators is done by the institution. There is an upfront fee schedule. There's no negotiation on fees between the parties, the institution and the arbitrators, because it's a set piece under the rules. And it removes the connection and the nexus of money between the party and the counsel and the arbitrator. The institution also helps to deal with the frequent appointments by a party, because the institutions require arbitrators to complete the statement of acceptance, availability, independence, and availability. So that requires the arbitrator to disclose circumstances that might be of such a nature to call into question his or her independence in the eyes of the party, or give rise to reasonable doubts as to his or her impartiality. And an example of the AETOS and Shell Western Supply Trading case in the English High Court, people will be familiar in this room of Dame Elizabeth Gloucester, who was removed by the ICC after disclosures were made in respect of frequent appointments by fresh shields, not only as arbitrator but also as expert in providing foreign law opinions in cases. And the ICC court decided on the challenge and accepted the challenge, which the ICC rarely does in challenges to arbitrators. Turning to DJP and DJO, I know my friend says this case is evidence of how the ICC has failed in the administration of arbitration. But I beg to differ, because if you look at the arbitration in context, there were 3 arbitrations in total, 2 of which were parallel arbitrations conducted under another institution. It was the International Center for Alternative Dispute Resolution in New Delhi, and had the other two cases been under the ICC rules, the ICC would be aware of the similarities in submissions made, and the 212 paragraphs copied from the other awards in the scrutiny of the ICC award that is called into question in the Singapore Court of Appeal. Now, and what the Court of Appeal found was, of course, that tribunal's decision was improperly influenced by a degree of anchoring bias, which refers to the unconscious tendency to rely on conclusions earlier made without regard to new information and fresh analysis. And of course, if the three cases were all administered by the ICC, this wouldn't have occurred. The arbitrator would be called to question, given my own experience of the ICC's rigorous scrutiny of arbitral awards. Lastly, in terms of ad hoc arbitration, I think the greatest example of a failure of ad hoc arbitration is the Sulu case against Malaysia. I mean, everybody here will be familiar with the case where the award was rendered under a 1878 agreement in which the Sultan of Sulu apparently gave European explorers exploitation and administrative rights in return for annual payments. That particular arbitrator was appointed Spanish arbitrator and seated in Madrid. It was an ad hoc case, and there were clear jurisdictional objections that could be made in the arbitration, which could have been dealt with had the arbitration been administered by an institution, because you have mechanisms under institutional rules where you can bring early jurisdictional objections, and the institution can decide on the objections before it goes to the tribunal to decide on the jurisdiction itself. So that particular case was a good example where it was completely ad hoc. It was seated in Madrid, then moved to Paris because the arbitrator decided to avoid the annulment of his own appointment by the Madrid courts. So, in summary, because I know my time is up, institutional arbitration can effectively curb corruption in dispute resolution because it provides the necessary guardrails to look at the corruption that exists, the corruption that we are talking about here in dispute resolution for the future and the better administration of cases. Thank you.
Good evening, everyone, and my apologies to MCIA and any other arbitral institution present in advance. I'm only defending my brief, just like any good lawyer ought to. The opposition has listed out several problems, and then they have concluded that we are better, that is, the institutions are better, please take us at our face value. And that's what the institutions want you to do, but let's face it, that's not the case. The topic is an oversimplification of the problem and an overstatement of the solution. That is what it is in essence. Institutional arbitration, in my view, is as likely to curb corruption as the US takeover of Greenland is going to put an end to the Ukraine conflict. Corruption may have many shapes and forms, but simply put, corruption is defined as abuse of entrusted power for personal gain. That's the basic definition as far as corruption is concerned. But at its heart, corruption is a social construct. The existence and acceptance of corruption is driven by society, and unless institutional arbitration promises inner transformation and social reform, then it is less than likely that institutional arbitration will have any meaningful impact in curbing corruption in dispute resolution. Ultimately, Aristotle has proposed this principle of essence and accident. I thought I was loud enough, so I moved it off. So Aristotle proposed this principle of essence and accident, the former being a set of attributes necessary for a substance's identity, and the latter being properties that it may gain or lose without having any impact on its identity. Parties, lawyers, arbitrators, witnesses, they are the essence of arbitration. whether you have CIAC or MCIA or LCIA or ad hoc makes little difference as far as the essence is concerned. Because it is the same stakeholders that are involved, irrespective of the means or the route you take to arbitration. The institutions themselves are drawing from the same pool. In most institutions, especially in India, the lawyers and retired judges are part of their panel. So ultimately, whether it is institutional or ad hoc arbitration, you are drawing out of the same pool of people. The essence is not changing just on account of institutional arbitration coming into force. And if corruption is at this cross-section, then institutional arbitration does not address the real challenges that are there today. In fact, just to simplify the opposition's case, the opposition would like you to believe that it is only Vyapak's presence that is keeping this from turning into a free-for-all. But I would respectfully submit that maybe with a little more time and a little less discipline, the four of us could have conducted this debate, and perhaps this jury and the judge would have reached the same conclusion that institutional arbitration is not likely to curb corruption any more than ad hoc arbitration is. In fact, there is nothing to suggest, and nothing has been submitted to suggest, that there is a problem that institutional arbitration solves. In fact, in a 2024 survey, less than half the arbitrators actually felt that ad hoc arbitration is more prone to corruption. In fact, I have not come across, at least in the Indian context, in any case where arbitrator corruption is cited as a ground for setting aside the award, even in the more recent decisions that have looked to cure the award. So in that context, this is, I would say very simplistically, this is a classic example of sales law, where you have a product and the product wants to create a demand. So then we have institutions, and institutions want to create that demands. And then what is to say that the same problems or challenges will not inform these institutions? There is no real oversight over these institutions. There is no legal framework that is holding these institutions accountable. In fact, the way I see it, these are private, opaque organizations with management boards that are comprised of those who form the essence of arbitration. It is the same lawyers and the same arbitrators who are sitting on the panels of these boards and these institutions, who are deciding what rules should be there, who are deciding how arbitrators should be appointed, who are deciding what the costs and what the fees should be. But of course, the opposition does not get into these issues. What are their internal principles and bylaws? Let's ask this question. I went to the website of a few institutions. I couldn't find any. I don't know how these institutions are ultimately deciding on what basis the arbitrators are being selected or appointed, or for that matter, if the president of a particular institution is appointing an arbitrator, what is the objective criteria that he is adopting? There just isn't any. So if my proposition today is that this is no different from the parties themselves deciding on who to appoint. The other aspect that is there, and Rebecca will touch on it, is that the overwhelming majority of appointments, even in institutional arbitrations, are by the parties themselves. So therefore, the biggest argument that they have, that there are guardrails, that the arbitrator appointment is divorced from party autonomy and parties don't decide, is something that is a non-starter. But even otherwise, let me ask a question. We have lawyers in the audience. How many times do we suggest arbitrators based on who we feel is easier or more difficult to deal with? Let's face it, it's a fundamental reality. Whether it is institutional or it is ad hoc, we decide on who we want as arbitrators, decide based on what is our perception of them. Are they commercially sound? Are they easier to deal with? Are they, I'm sorry, I didn't want to use that word. Are they difficult to deal with? So these are real practical aspects which will not go away simply because there is an institution that is involved. The opposition has told you all the ways in which your life can be easier, not better. There will be a schedule, files will come on time, there will be somebody coordinating. but they haven't told you how the process is actually going to improve. In fact, some of these, for example, secretarial assistance is part of the 2024 amendment. So why do we need institutions? Ultimately, all arbitral institutions are in the business of arbitration. They need the patronage of clients, of lawyers, of arbitrators and experts in order to establish and flourish. So one may argue that institutions are open to the same risks and pitfalls. And therefore I submit that there is no point in changing the means if the end remains the same. Let me also say this, that independence does not ensure propriety. Arbitration institutional other right is ill-equipped to deal with corruption allegations, and Rebecca will deal with it in hopefully in her rebuttal. But there is no way for the arbitration process itself to determine whether corruption is involved. There is no mechanism. Arbitrators are not before the court. It is impossible to prove. And even if you apply the red flag approach, ultimately, how does the arbitrator defend himself? So you're creating a situation where there is no framework to assess and simply condemning ad hoc arbitration on the basis of what is the perception. Let me just say this, that corruption requires deterrent, not disincentive. If we really want to make meaningful change, we should take active measures, for example, bringing arbitration under the Prevention of Corruption Act, making appointments more objective, having a legal framework for blacklisting, for ethics training, for arbitrator trainings. We should train arbitrators and lawyers in best practices to move away from a more traditional trial approach to arbitration. And mandate training for arbitrators, even if they are retired judges, so that they are able to inculcate the best practices when they come into it. Ultimately, arbitration is a private dispute resolution mechanism that is premised on party autonomy, and I would say, and I would end with this, that do not invite a plumber to solve an electrical fault. It's not going to take you far. And a sincere request to MCIA, please don't blacklist me. I'm sorry, you don't have the authority to blacklist. So that's the entire problem with institutional arbitration. Thank you.
So in 3 minutes, allow me to gently yet thoroughly sweep aside the cobweb of skepticism spun by our learned friends on the other side. What they say is actually that you, as a corruption, being the bathwater, you throw that out the bathwater, but without realizing that you cannot throw the baby with the bathwater. They are two distinct things. My learned friend wants now us to think not about arbitrators, ad hoc or institutions, but plumbers and electricians. Let me take that analogy. As rightly contemplated by Mr. Mehta, that you have to first identify the problem. If the problem is water leakage, it has to be plumber. And if it is an electrical fault, it has to be electrician. The problem is not getting the professionals. Problem is identifying the problem. The whole point therefore is that if the corruption is identified as a problem, then the issue comes which and who are better placed. Not only better placed. So what he says that, in fact, Rebecca admitted that what are the admissions? A, corruption is a problem. B, that it is an issue to be dealt with. And 3, institutional arbitration are exceptional institutions. Is what is admitted. Now, what my learned friend says is that if Vyapak wasn't there, it was free for all, yet he would have behaved. So therefore, trust the parties. Yes, parties should have autonomy. But when autonomy turns into anarchy, institutions are referees that blow the whistle. It is not interference in the process. No one can, only the arbitrator does. But when it goes the side way, there is a referee required to blow the whistle, which in ad hoc no one does. Which is other process pointed out? None. He says that the institution itself will have that same compliance built into it. Sure, institutions can also err, but at least they have the fingerprints. In an ad hoc setup, corruption vanishes like a ghost in a courtroom. Then he says that end remains the same, whatever you do, because what you have actually done is not suggesting a better solution but only an easy solution. Between a system that stumbles towards fairness and one that hides in informality, I take the one with rules, records and redressal any day, and not something which, as he rightly pointed out, only goes on your social fabric. So, if his argument is taken that if you are socially uncorrupt, you will not do corruption either ways, then there is no problem, no solution required. But if you consider this as a problem of something like corruption, the question, the motion, my dear friends, is presuming that there is a corruption. And once that presumption is there, you will have to vote whether institution is better fed or institution can do something about curbing corruption. Now, very important, the motion is very, very smartly drafted by smartest people. It says can. It is not admitting that it has or it is the only one who can do it. Neither of these words are not there. Neither vote only and neither a past tense like has. It says it can. Why can? Because it is the institutional format, which is the only format where the evaluation where there is a continuous evolution. Evolution with the intention to have the integrity, to save the reputation and the fairness in the entire process. Now, Rebecca also talked about. She talked about confidentiality. Now, confidentiality cannot be a clock behind which an arbitration must hide, because it is only that the confidentiality, when it is short, even the most well-intended process can become susceptible to corruption. My learned friends, you continue to vote for the motion and you will see that the entire house is with you. Thank you.
Thank you very much. Well, I've somehow found my way through the cobwebs to the podium. I'll keep this very brief. One point of clarification and 3 brief points of rebuttal. The clarification is this. I said right at the start, and we've agreed all along, it is common ground that corruption is an issue. But that is not what those with the motion need to establish. What they need to establish is that institutional arbitration can effectively control that problem. We're focused on if it is the right solution or a viable solution. We say it is not. Now, rebuttal point 1, the role of arbitrators. We've had various arguments raised in each direction, but fundamentally, where we get to is that you're looking at, in the majority of cases, the parties nominating the same people who are then agreed to by the institutions. In any event, you have people drawing from the same narrow pool of arbitrators, which is a problem we need to fix. And you have, even if you've got mechanisms such as the ones Katie's discussing about additional challenge mechanisms, more scrutiny of fees, well, frankly, there are challenge mechanisms anyway. Problems will exist in spite of them. And actually, with respect to the direct connection with fees, it is rarely the payment of agreed fee rates that is the problem. We've talked about the Fulbright of corruption. That is not the central issue that we're dealing with most of the time. Rebuttal point 2, scrutiny of awards. Some institutions do not look at the award rule. That is absolutely fine, but we should not delude ourselves and think that that is an inherent part of the process. Even those that do, the level of scrutiny is to check for obvious error. It is to look at it. It is not reasonable to expect an institution to read an award having not been involved in the hearing at the end of the case and tell you if fraud or corruption has arisen on the part of the parties or the part of the arbitrator. And even the most diligent and experienced person would rarely be able to pick that up, if at all. Now, on the copy-paste job, we are left as hired to speculate what the result would have been if all arbitrations had been before the same institution. Even if it had been a different result, picking up on 200 paragraphs being copied and pasted may have been important. I guess we don't know for sure. But what we do know for sure is that a lot would not be caught by that process even when it does exist. Rebuttal point 3. Simply thinking about the distinction between institutional arbitration as a process and grounds of challenge that exist under national law. Because this has just come up a couple of times about the ground of basis of setting aside awards on the basis of fraud or corruption. Now, yeah, this is very important under national law, but these mechanisms are a check and balance on arbitration, and under many national systems are there regardless of whether it's institutional or ad hoc. But what it doesn't have much to do with is whether institutional arbitration is getting it right to start with, or is capable of avoiding ending up with the courts where you do have transparency, where you do actually have judges stepping in to scrutinise what's happened, getting to a different result. And to conclude on one brief final example, this illustration had more to do with the parties and the arbitrators, but many in this room would be familiar with the Nigeria and PNID decision, which arose. And now in this case, Nigeria challenged an arbitration award worth $11 billion before the English courts, alleging that the underlying contract was secured through bribery and other deficiencies in the arbitration process. Importantly, the court found that the corruption involved in procuring the contract was not sufficient to warrant the set aside, but the process in which the award was obtained by fraud was justified to non-enforcement. In particular, the judge found that the legal team had improperly obtained and retained Nigeria's privileged documents, it had relied on material evidence which it knew to be false, and it had bribed a Nigerian official to buy her silence in the arbitration proceedings. Now, the stakes could not have been higher, and this was an LCIA arbitration, and the panel was comprised of 3 of the most eminent and experienced arbitration practitioners and retired judges that you could come across. So this is not evidence that our institutional arbitration is not capable of curbing this problem. I don't know what it is. Now, final remark, and not as poetic as Aristotle, but a quote did come to mind as we were sitting here listening to the arguments, which is something that Mark Twain once said, which is that to a man, and I'm going to make this gender appropriate, say to a person with a hammer, everything looks like a nail. Now, institutional arbitration is the hammer, but corruption is not actually a nail. Institutional arbitration is a solution to many things, but curbing corruption effectively is not one of them.
So I think we have heard both the sides of the motion. We started with the raise of hands. And we have now heard both the sides. So can we do a vote again and then maybe have some comments from the jury as well before the judge gives his final word? Can we go for the motion still? Can institutions serve? Against the motion? Okay, so that's jury obviously has been a little balance, or rather tilted the balance against the motion. Unless it's corruption. So with that, let me see for the words from the judge. Of course, before that, if there are comments or suggestions, please.
I'm reminded of a small incident from a personal ad hoc arbitration which I did within JEF 3 years back. So we were the respondents over there. The claimant files a Section 17 application during the tendency of the arbitration, letting bank guarantees not be invoked or be restrained from invoking his bank guarantees. Now, under the disguise of a Section 17 order, the arbitrator calls the bank and asks him to deposit the bank guarantee, the physical bank guarantees with the arbitrator, and ultimately goes on to pass the award that the bank guarantee amount will stand adjusted with the main award. Now, without getting into whether this was corruption or not, or whether had it been institutional instead of ad hoc, this was better. So, can a Section 17 be exceeded to the extent that someone who is not a party, the arbitrator in an ad hoc arbitration ordered the bank, called the bank person, and took the custody of the bank guarantees with him? Any thoughts or any comments from any of the panelists?
Okay, so definitely this is not part of the discussions so far. This topic is concerned, but Vishrov, do you want to give a quick comment? Otherwise, maybe we can take more relevant comments so far as the topic is concerned. But Vishrov,
I think actually it takes all sorts. I think he's probably not as egregious, but we see things that may not make sense even in the traditional judicial system. But that should not be an indication that there's something wrong with the system. These are just anomalies.
I don't know whether that answers your question, but basically that's not normal. Right? I don't think an arbitrator or a judge would have that kind of power. Yeah.
And essentially showing an act of corruption.
But that's more of a process-driven issue, even if it's institutional. Once the arbitrator is appointed, this can see. So I don't think institution can avoid this situation, except the fact that possibly they can select a little more trained or a person with better legal skills or acumen. That's what institutions can do, but this can still happen in an institution. Ashutosh, you had some.
Just one small point. I think my answer could have been, when you the raise of hand, it could have been different if the question was if institutional arbitration can eliminate corruption. That it cannot. But I think when it comes to curbing, it definitely has certain processes that can reduce the chances of corruption. But I don't think it can eliminate. That was one small point I wanted to make.
Okay. So now there is a debate between difference between curbing and eliminating, but I guess maybe this is the topic.
Point.
Yes.
2 points to the esteemed panel. One is, I'm talking from the Indian perspective. So, talking about 2 cases. In one case, the extension, post the initial extension, this was an institutional arbitration case. The initial extension, then subsequent extension under 29A went before the High Court. Now the High Court, while granting the extension, gave the discretion, do you want to keep the judge or do you want to keep the arbitrator or change it? That basically essentially meant that the judge was taking over the discretion, which either if it's ad hoc, in the process of ad hoc, it gets followed. Even in the case of institutional, it got followed. Second instance, while appointment of a institution, while an institution was appointing an arbitrator, the other party challenged it, stating it was an ex parte appointment. Then that again went to the High Court. These are live cases which I faced through. So I'm basically going on to the point that even if it's institutional or not, the High Court judges are not in favor of such because they are giving the discretion and overgoing also what the institutional process would be. In such cases, and this happens in open court, so both the parties, the advocates, everybody be prejudiced towards institutional arbitration also in such situations, or against rather.
So this is again a little generic question on ad hoc versus institutional and whether court system should support institutional arbitration more than what they are doing now. But I think it's a little away from the debate in that sense. But yes, the court should naturally and logically support more institutional rules and arbitrations, and if they are appointed by the institutions and not interfere. But if they are doing it, I don't think that again has any relevance from a corruption perspective. I think what we are trying to debate is once you come under the institutional rules and everyone, including the courts, are supporting institutional arbitration, can it curb corruption? That's the question.
Okay, so that, I mean, I was trying to raise that point only because this autonomy which the institutions are supposed to get, and I mean, it's not being given to them. Hence, probably it's not even aligned to the
possibly somebody in the court system also needs this training, but that's the only outcome of this decision. I think there was something at the last. Maybe we can just take 2 questions or comments and then.
Good evening, everyone. The biggest source of alleged corruption comes from the choice of the arbitrator. When we say that arbitration is an alternative to the court mechanisms, while filing a suit in the court, we do not have a choice as to before which judge our suit or claim would be placed. So, can't we have an automated mode, like we can draw inspiration from the insolvency code, like IPs are appointed on ad hoc basis at the choice of the court rules. So, can we have a natural system, neutral system, automatic system, keeping a high standards of qualifications of the arbitrator, and then whenever a dispute arises, it can automatically be allotted to random arbitrator without human interference. So, because the biggest source of corruption is upon the choice of the arbitrator. So, can those sort of things be implemented because there are provisions for expert appointment? If a judicial person is appointed as arbitrator and it relates to a maritime dispute, a maritime expert can be appointed by that fellow or such that arbitrator.
So, at least SEBI, before this ODR regime came in, SEBI cases, when it went for appointment of arbitrator, used random picking of arbitrators from their list. So, emails used to come automatically from the system rather than human intervention. So, some of these things have been implemented in some forms, but that is still a little more closed environment of SEBI and cases and only people who are independent in SEBI. What we are trying obviously to discuss is much larger. I think Nitin or someone says 90% of cases. I don't know 90% of how many cases, but we are talking about humongous number of cases, and therefore, who are on the panel and how that randomization for picking up would happen and things like that would obviously raise similar doubts. And it still requires a human intervention because you still want to select an arbitrator who is most appropriate for that case rather than a complete randomization. Right? So there are issues in complete randomization as well. And therefore somebody sitting there can possibly do both. They would use randomization method but select it from more relevant arbitrators for a case which requires a particular skill or experience and things like that. Any last? Anybody?
I just add to what Vyapak has said. Apart from a man or a person deciding it, it's the panel which decides. So that panel can then do a kind of a random pick among most suited arbitrators who could be appointed. So that instead of one person doing it, there are multiple persons applying their mind to have a panel among which then it can, be applied. But human intervention will be required to even figure out that these are the 10 most suited.
I think we'll finish as of now, but if you have some last point.
I would like to.
Please.
Thank you. We talk with it, but not too long. Honorable Justice Karia and panel members, thank you. Good evening and thank you for a lovely discussion. I sat through the day. This is my first arbitration conference. First, a comment. I was on the fence throughout. because I believe in absence of any primary data and being new to this, you cannot take a stand. So I was on the fence and I remain on the fence. But Mr. Mukerjee just, I think, left us. His arguments swayed me a little because it's about, he turned towards human beings. So I appreciated that. Now the questions. In a post-truth world, where almost everything can be doubted, where it can spread very easily through our mobile phones, it's very easy to doubt any narrative. So I wonder how can a trust building or image building exercise can occur in a world where courts are always seen as whether deterrent or the enforceable entities. We've lived like that as a civilization. And I wonder whether this debate, the underlying point here is, are these institutions, whether ad hoc, whether institutional arbitration, is it trying to still imitate what courts hold for us in human civilization society? If not, can somebody or any of you make comments on what we are trying to achieve long term? Corruption can be one facet of working out, but there can be other things.
So, a very interesting question indeed. If I can rephrase your question, what you say is that as long as years go, we had a particular set of procedures and independence of the court in our mind. Now, that is to be substituted. So, that is being now substituted by institutional arbitration body in a course correction. So, therefore, you say that what is therefore new in it and what is that the institutional, by this change from court to institutional arbitration, what are you going to achieve? If I have got your question right. So therefore, now you, as someone pointed out, that the jurisdiction of the court is fixed for every one of us. But here there is an autonomy, party autonomy to choose at least the institution and the rules which goes to it. Again, the strict rules of CPC, which goes back for 100 years, are now streamlined by these institutions to modernize it and to walk through the coming years and at present. So therefore, what the courts now fail to do is to deliver justice in time, is what institutions are trying to achieve now. So that's the goal. B, the topic of corruption. Again, from the court, I can't say, but that is creeping in, where again the systems are to be updated by the institutions to even have this menace out. So it's the constant and the swiftness with the institution, arbitral institutions can update itself, is what the achievement would be.
So maybe we can now have the final word from the judge.
Good evening, everyone. It was a very interesting debate on a very pertinent question. As I've been part of all the MCIA conferences, especially in Gujarat, it's always a pleasure to come home because Ahmedabad is my home. And be here as a part of the judge in a debate. And this is my first MCIA event after my arbitration. It's a very special event, especially with Vyapak and the excellent team on both sides. It was very tough to decide. I saw jury also had a change of heart after the debate. So well done, both sides, excellent performance. But the core issue, what we need to grapple since morning and otherwise also which we know is that there are certain issues in the entire arbitration ecosystem in India, and we need to understand those issues. We all know what the issues are and how to fix it is the big question we have several speakers speaking throughout the day, starting from the first session, we had judges from Supreme Court, High Court, Solicitor General, Advocate General. Everybody has created a sense of urgency in the need to resolve these issues which we are facing in the field of arbitration. And the only answer, as I think, is an institutional arbitration to all this problem. Because what is the problem we have identified so far is the trust, the lack of trust in the arbitration system. How we can rebuild the trust, or how can we get the users of arbitration to kind of use arbitration as compared to court system. If you are thinking the court system is an alternative to arbitration, it's a myth. It's not going to be possible because there is so much of pendency in the Indian legal system, and you don't have actually an alternative to arbitration. So I think the arbitration, as Vyapak always says, is not an alternate but is an appropriate dispute resolution system. We have to accept that as a reality. Now, having accepted that, what can we do to improve it, or at least do it the correct way than what we are doing now? What I feel is that institution, as the team on my right said, has a lot of advantages, and the question is very narrow. Can an institution curb, and I agree with Ashutosh, it's not about elimination, nobody can eliminate, but can an institution curb the corruption? And when we talk about corruption, it's not about the corruption in a traditional sense. Corruption is a very wide term. We can't term the corruption as favoring somebody or taking money or deciding something. Even unconscious bias, an issue bias or a role bias can lead to corruption. There could be many such actions the arbitrators can take which may not provide a level playing field or equal opportunity amongst the parties, or not give full opportunity to present their case, can also be termed as corruption. Of course, we have added the arbitrator immunity in our legislation by amending the law in 2019, added section 42B, which gives the immunity. But there is a condition for that immunity is good faith. Now again, a good faith is a very wide term, and if you are having anything other than performing your duty as an arbitrator in a fair, unbiased, independent and impartial manner, then I would say it's a corruption in the sense we are discussing today. And what we are discussing today is with regard to a comparison between ad hoc versus institution. It's not about arbitration versus court. So let us be very clear, we are talking about the arbitration and whether institutional arbitration can help in curbing that kind of a perception of a corruption, what we all talk about. And the corruption in a larger sense when I use the word corruption. So if you see what are the institutions do, the institutions have time-tested rules. These rules are revised from time to time, and if we see MCIA has revised the rules which has come into force today. After a long period of 8 years, I was part of the CR Court of Arbitration. The CR has revised the rules. And when we sit and discuss the need to revise rules, we take into the best practices across the globe and try to invite that in the process of arbitration. Arbitration is all about process, and who mends the processes is the arbitrators. So there are various touch points in arbitration when it comes to the entire process, starting from selection of arbitrators, challenging their applications against their independence and impartiality, setting aside of the award, scrutiny of the award, and enforcement. So institution provides an ecosystem which is having a global standard. And even if you talk about Indian institutions or international institutions, they have the same standard. If you do a comparative analysis of the rules of these institutions, you will find that most of the rules are very, very similar. Language may be different, but the intent and the outcome of all these rules are very similar. So that helps to bring standardization, it brings to bring uniformity in the entire process of arbitration. And even arbitrator wants to do something outside the process, it is impossible because the parties have pre-agreed to these institutional rules. Even the fees, for example, many times we hear a complaint in the middle of the arbitrators want to change their fees or they don't want to give the full opportunity because there is a fixed fees. All that can be easily be handled by institutions because they have the fee schedule, they have the cost calculator on their websites. So all this really help in my view. Those who change their mind after the debate may also would like to consider this point, because if really we want to manage the arbitration process in India and bring foreign parties to India who have no connection with India, and we are talking about medical tourism, we have nobody, and also we spoke about the arbitration village. We can always talk about arbitration tourism in India, where there is a clear advantage India has. And India has the common law background, English speaking bar. We have now established Arbitration Bar of India, which is an association of lawyers who really want to specialize in arbitration. It's an era of specialization now, and we need to see that the arbitration is taken up as a full-time Monday to Friday, 9 to 5 type of practice, which all of us who are in this room and outside should really focus on. Training is integral part, where training of the arbitrators, training of the lawyers, we spoke about that. MCIA, Vyapak, and earlier I used to be very active on the training part on the CIA, which really helps. And we all have gone through that training, so we know it really helps for the younger generation. It's a great tool to enhance your abilities to do arbitration. And transparency, I feel, is the best way to curb anything which can be perceived as not ethical. And if you publish names without of the arbitrators who have passed awards, which and how many they have passed, how many have been set aside, without naming the parties, confidentiality cannot be an issue. And we should also have ethical standards for arbitrators. We talk about ethics for lawyers, we talk about the process the parties have to follow. But arbitrators also are a creation of contract, and if they don't follow certain ethical standards, then maybe the repeat appointment may not be there, or they may not be appointed again. But the reputational loss, or if they are not performing in the way they are expected to perform, then definitely some repercussions should be there. Maybe in terms of the fees, or in terms of appointment, or in terms of at least naming them and putting, identifying them as the arbitrators who need to improve. It's not that it's an end of career for an arbitrator. There may be perceptions like and instances where a party feels that there is a corruption or a bias, but it may not be. A strict arbitrator who wants to follow a certain process can be unpopular, but that doesn't mean that arbitrator is not ethical. So there are a lot of aspects to the ethics aspect, and therefore institution can really be a watchdog or an overseeing mechanism. We also are thinking of setting up an arbitration council of India, which will then have an umbrella body over the arbitral institutions. So there would be some kind of sanctity and accreditation with the arbitral institutions, arbitrators, and we will bring the arbitration at the international level. And that would reduce the court intervention, because now I'm sitting on a commercial appellate division of the High Court, and we see a lot of appeals coming from the award and the 34s for the challenge of setting aside of the award. And the quality of award, when we read the award, it's very easy to make out whether the arbitrator has understood the issue or not. And once we have a database, artificial intelligence can help. There are already collaboration with Nitin spoke in the morning can be advanced, and this is the beginning. The technology is going to really help the entire ecosystem of the arbitration, and with the large institutions, they can deploy those technologies, which in ad hoc we won't be able to do it. There are hundreds and thousands of awards where there is also a proposal now under the new amendment, which has not been yet notified, is to have a repository of awards. And if there is a artificial intelligence which can analyze those awards and see what kind of issues we face in terms of the understanding of the contract and who these arbitrators are. And we need to increase the pool of arbitrators also. And with that can happen if the lawyers and the professionals who are really wanting to devote their time into the arbitration process and have to undergo the training for the arbitration, and they can easily become arbitrators. We had that topic also today during the day. We discussed that. So overall, we have to ensure that collectively we can definitely eliminate corruption, right? And with the help of institutional arbitration, I feel, and I would give decision in favor of for the motion that at least the institutional arbitration can curb the corruption which is perceived in the field of arbitration. Thank you.
So, thank you everyone for staying back. I know we have taken 10 minutes more in this process, but this was an important topic. As I said, it was discussed through the day in almost every session, so it was a nice way of closing this conference. With that, maybe there is a short valedictory, or you have already done.
I think in the interest of time, I have spoken what I wanted to speak, sir.
Okay, thank you.
Yeah, I can add one thing is that
MCIA is the best, which really wanted me to say.
Some form of corruption we have seen.
No, it's not corruption, it's affection. Judges are human beings.
I would like to thank Honorable Justice Karia for delivering the valedictory address. I would like to thank the sponsors and supporting organizers for making this event a success. I would like to thank the panelists for this interesting debate, and of course the other speakers of the panels for the insightful discussions that we had throughout the day. And finally, I would like to thank the audience for the participation and for being with us throughout the day. And we would like to see you all next year for the 5th Annual International Arbitration Conference.